All right, moving on to our next section here under security and risk management, our compliance section. Compliance, obviously, by definition means, are we meeting the objectives of the security program? So information exchange is a key element of that. Flow of information over the internet has changed significantly how we share information. Everything used to be localized to the business back in the day, and now pretty much everything is shared over public domain, which means that we're going to have different protections in place to protect our intellectual property, our trade secrets, our market data, personally identifiable information, and so on. And new laws and regulations have been created because of this. We've seen a lot of changes. In fact, ISC² has a certification now specifically related to security compliance within a cloud environment, right? So we have different legislative bodies, we have different government agencies that regulate the processing and transfer of personal information, particularly over public domain. Think about it from a hospital perspective, right? Hospital records, medical records, in the past traditionally have been stored in a filing cabinet at the hospital. So as far as compliance goes with maintaining those records securely, you just had to make sure that those records were logged in and logged out of a medical records room that had locks on the door and had locks on the filing cabinets and so on. But now everything seems to be stored electronically. Most everything is stored electronically. Doctors are working from different areas. They're asking for medical records to be transferred or transmitted for review and shared. And that means that HIPAA compliance rules and regulations are going to change based on that. Standards bodies, we've already kind of seen an introduction to standards bodies as part of this process, help us develop best practice standards so that organizations can do what we call self-regulation. They can implement these standards with the goal in mind of ensuring that they're protecting their customer assets, what we would consider to be due diligence and acting in due care on a daily basis based on the information assets. Some of the standards and regulations, some sample laws, the Data Protection Directive. I'm not going to get into these in a lot of detail, but DPD 9546EC is a European directive for baselining, a European directive baseline for national laws and legislative bodies for rights to privacy. Australia's Privacy Act, Argentina's Personal Data Protection Law, Canada's Personal Information Protection and Electronic Documents Act. That one, surprisingly enough, was on my test. This one right here. They didn't call it Canada's Personal Information Protection and Electronic Documents Act. They call it PIPEDA. In fact, they were asking what regulatory standard is used in Canada, and all you got were the acronyms. So that was kind of one of those questions I had to completely guess on. I mean, there were a couple in there that I could eliminate, like NIST, special publication, and whatnot. But I did not recall, even though it was specifically listed in the courseware, the PIPEDA standard, right? The United States uses a sector-based approach. And we're going to get into some of these specific sector-based concepts a little bit later on. There are laws that generally govern how business sectors operate. For example, the HIPAA guidelines, right? HIPAA is the Healthcare or Health Insurance Portability and Accountability Act. I think that came out in like the mid-90s. It was based on, a statute that was initiated by the United States Congress. I think it was signed into law around 96, I think, when Bill Clinton was in office. But the whole goal of HIPAA was to kind of modernize the flow of healthcare information. But specifically, it defined how personally identifiable information was maintained by the healthcare and healthcare by healthcare insurance agencies and healthcare insurance industries, but also healthcare in general. Even though it was Health Insurance Portability and Accountability Act, initially it was identified to provide limitations for healthcare insurance coverage, but then it became, it kind of started to cover other entities in the healthcare space as well. There are 5 titles. One involves protecting health insurance coverages for workers and their families. But as the act has gone on, it also talks about protecting, preventing healthcare fraud and abuse, medical liabilities, the right to access personally identifiable information, who has access, how do we disclose that information to, say, relatives, what is a transactional code set of rules, and so on. So it's quite extensive, but what you need to know from a exam perspective is, of course, what types of standards would apply to what type of sector, right? The GLBA, for example, the Graham-Leach-Bailey Act, this was the Financial Services Modernization Act of 1999, also came from the United States Congress, the 106th Congress, I guess. I don't know why I know that, but anyway, and it was obviously applied to financial institutions, banking companies, security companies, investment banks, commercial banks, and so on. And this came about because of issues with Citicorp and other major bankers, Primerica, Travelers, because of different violations. And again, you don't need to know the specific restrictions of the act, but it does provide things like privacy rules. It provides for safeguards to protect financial institutions. There's also pretexting protections that are built in. Financial institutions could be mortgage lenders, real estate appraisers, loan brokers, debt collectors, banks, real estate settlement providers, and so on. And again, you don't need to know all of the specifics, but it does provide for things like consumer and client privacy rights. It defines what a consumer is, what a customer is. It will define how notices are required to be deployed, and so on. And PCI, often referred to as PCI DSS, the Payment Card Industry Data Security Standard, prevents credit card fraud, and certain organizations that facilitate credit card transactions are required to be PCI DSS compliant if they have a certain number of transactions or if they meet a certain threshold. There's a qualified security assessor that can come in. You can do a self-assessment. We've done our own self-assessment and provided documentation to our payment card provider or processor for our PCI compliance. But other organizations that are much larger might need a qualified security assessor to come in and evaluate whether or not they're meeting the PCI standard. All right. So what is governance, what is risk management, and what is compliance? Combinations of business and technology challenges exist in risk management, finance, operational risk assessment, and IT, right? Governance, risk management, and compliance, or GRC, analyzes risk and manages mitigation of that risk. Now, we're going to get into much more detail later on about risk assessments, risk discovery within an organization, and identifying how we manage risk within the organization. GRC is just an example of another framework that allows us to, well, I wouldn't necessarily call it a framework. I would say it's kind of more of a guideline to identify how we structure risk management in our organization. All right. So governance, of course, is focusing on the activities that are responsible for identifying the stakeholders in your security assessment program, who are the decision makers, who's going to be accountable, who identifies those performance metrics and who measures those metrics, and so on. Risk management is the act of actually identifying assets within the organization, evaluating those assets for based on a particular threat landscape or threatscape, evaluating those assets for vulnerabilities, and then identifying what the risk level is for those assets, and then further identifying what our acceptable risk appetite is for those assets. For evaluating the risk, looking at risk, reducing risk, accepting, transferring, etc. And then compliance, obviously, is a way for us to ensure that we're meeting the objectives and the goals of our security posture. All right, we integrate these elements to increase the overall effectiveness and the efficiency, but decrease complexity. This is a really important concept. If the security processes that you implement, the security features you implement within your organization are too complex, they either won't be implemented or they won't be implemented properly. So we want to make sure that we have a very effective risk management strategy and security strategy that is thorough and inclusive, but isn't so complex that it's easy to make a mistake, to generate a hole, so to speak, or to introduce some concept of a violation because it was just too complex to implement. Does that make sense? All right. Now, GRC is again, it seems like a relatively generic concept, but it actually is a, kind of common to just about every framework that we look at throughout the class. If we look at governance, we manage and control enterprises and divisions via targets, responsibilities, and control mechanisms. We're not talking about government. We're talking about governance, managing, right? So risk management input, risk management information, identifying assets within the organization, identifying the vulnerabilities of those assets, what's the likelihood and impact that an attack is going to occur and whatnot. That is going to go provide input into how governance is going to be developed and maintained. The governance, in turn, will provide control mechanisms based on our risk appetite, based on what we're accepting within our organization, the different tools, the different assets that we're protecting, who's responsible for protecting what asset, and so on, and the controls that we put in place, the technical, administrative controls, the physical controls, and so on. Also, if you look at risk management, this is where we identify, assess, evaluate, remedy, and monitor risks, and define what's acceptable risk within our organization. Compliance may help define that acceptable risk. An organization that works with the federal government, for example, is driven by compliance, not by finance. I mean, there may be some financial component to it, but they're more driven by compliance and regulatory restrictions than they are by operational cost and whatnot. So you may define an accepted risk, but that accepted risk, you may define an accepted risk based on, for financial reasons. We're going to accept this risk because it costs X, Y, it costs $100,000 to mitigate it, and the risk is only $10,000 of cost to us. But you would be out of compliance if you accepted that risk even at a low value. So you may be required to implement mitigation techniques that ultimately would cost more than the risk introduces because you need to meet compliance requirements. So compliance can drive that. Compliance also provides, of course, input to how we govern our security architecture. And what are the requirements that lead to specific governance components. And then the output here is what are the controls that we're putting in place and so on to audit compliance, to ensure that we're meeting compliance standards and so on. It could be laws based on the region that you're in, could be regulatory requirements based on the business sector you're in, or it could just be based on standards and policies if your organization is certified by like an ISO type of certification. Even though ISO is voluntary, if you're ISO 27001 compliant, or if you're certified ISO 27001, then you're voluntarily applying those restrictions to your organization, if that makes sense. All right. Legislative and regulatory compliance. As a security officer, you need to understand the laws and the regulations of a local country or an industry. Now, I will say that, as a security officer, most likely you're not going to also be a lawyer. So you may have a legal team that provides input on these different types of regulations or whatnot, because you're not completely versed on the law, so to speak. But you still need to ensure that you're incorporating that input, right? Governance and risk management processes integrate these requirements. Laws and regulations provide specific actions for compliance or safe harbor. That is the term that I didn't define previously. I'll just do this right here. Safe harbor. Safe harbor is provided, well, it's actually kind of defined right here. Safe harbor is provided to organizations that may fall out of compliance or maybe potentially have opened themselves up to some sort of litigation because of a breach or some sort of incident that happened. And a safe harbor law or safe harbor protection means that you are protected from prosecution because you used due care and due diligence and the incident still occurred. Just because a breach occurred doesn't mean that you're going to be financially responsible for that breach. All right? So if you acted in good faith, you may be protected from prosecution, at least criminally. Civil laws or civil protection is a little bit harder to achieve, but criminal protection can be easier to achieve as long as the organization is acting in due care, acting with due care, and is performing due diligence, right? The Federal Information Security Management Act, I mentioned that in one of the previous slides, mandates that specific actions, standards, and requirements are implemented to ensure sensitive information and vital services are not disrupted, distorted, or disclosed. That's a very, very brief description of FISMA. Specific laws and requirements should be cited, and governance programs and informational security training programs should be put into place to make sure that you are meeting the compliance and regulatory, legislative and regulatory compliance requirements. Okay? Privacy laws are introduced complications for security professionals as well. because they do change over time. And they can be quite inclusive, these privacy laws. Protecting personally identifiable information, protecting private information is an extreme challenge, especially with the way that information is shared today. PII, or personally identifiable information, can be valuable to many people. It can be valuable to marketers. It can be valuable to cyber criminals, other threat actors that might exist. But personally identifiable information is classified differently depending on the operation of the business. For example, posting information on social media. If you post your social security number, or you post your driver's license number, or any other personally identifiable information on social media, you are not protected because of the acceptable, the AUP, the acceptable use policy, and the terms and conditions that are presented to you when you sign up for Facebook, right? So Facebook is limited from liability because of the terms and conditions that you agreed to. But other organizations that collect your personal information, healthcare organizations, etc., they're going to have much more stringent restrictions on protecting that personally identifiable information. We will talk later on about the rights of individuals with regard to personally identifiable information. What is a data owner? What is a data custodian? What is a data user, etc. We'll get into that a little bit later on. Data controller is mandated. The data controller is the individual that's utilizing that information. Well, maybe not utilizing that information, but providing access to that information, is mandated to implement technical and organizational measures against the unlawful destruction, accidental loss, and unauthorized alteration or disclosure or access to personally identifiable information. Individuals' rights include the right to know who the data controller is, who is going to be receiving that information, what is the purpose for collecting and processing the information. If the information is inaccurate, how can I rectify that? For example, if somebody is misreporting credit card usage or some other credit-related information to the credit bureau, what steps can I take to rectify that false information? What is my recourse if the data is used without my permission, or it's used unlawfully, not for the purposes that it was intended for? Okay, what is my recourse in that regard? We'll get into that in a lot more detail in some of the future sections here.